Hello. Today I'm going to talk about the interplay between the False Claims Act and the COVID-19 funding programs. Just to review, the False Claims Act, also known as Lincoln's Law, was passed during the Civil War in response to profiteering by companies that sold worthless supplies to the Union Army, guns that didn't shoot, uniforms that disintegrated, ammunition that didn't work. President Lincoln advocated passage of the law to respond to that kind of fraudulent behavior. And the law contained what is called qui tam provisions, allowing private citizens to sue on the government's behalf. Qui tam is short for a Latin phrase meaning he who brings an action for the king, as well as for himself. The FCA creates civil liability for knowingly submitting or causing others to submit or agreeing with others, which is this conspiracy provision, to present false claims or use false records material to false claims, seeking reimbursement from the government. And it's the federal government we're talking about here, because the False Claims Act is a federal statute. However, most state jurisdictions actually have state analogs to the Federal False Claims Act. So in many state jurisdictions, if there's evidence of fraud against state funding, you can bring a False Claims Act under the corresponding state law. Liability under the federal law requires that you act knowingly, but knowingly does not necessarily mean you have actual knowledge. If you put your head in the sand, often called deliberate ignorance or willful blindness, that is enough to prove knowledge as well under the statute. If you act recklessly, with reckless disregard of the truth, that also would amount to knowledge or acting knowingly under the statute. However, no intent to defraud is required, and evidence of an intent to defraud is not needed. Because it's a remedial statute and has a broad sweep, the definition of claim is correspondingly broad, and it includes any request for money presented to the federal government or made to a contractor or grantee if it is being spent on the government's behalf or to advance a governmental interest, and the government either funds or reimburses the contractor or grantee for any portion of the money requested. Failing to return money owed to the government can also be a false claim, and that is called a reverse false claim. The FCA authorizes recovery of 3 times the amount of the damages actually sustained by the government. And it also authorizes imposition of civil penalties for each false claim submitted. Those penalties are mandatory if, in fact, a lawsuit proceeds to verdict or judgment and the plaintiff prevails. In that event, those civil penalties are actually mandatory, and they can amount to many, many millions of dollars, tens of millions of dollars, depending on the number of individual false claims that were submitted. If those false claims are done with intent to defraud, there can be as well a criminal prosecution based on the same conduct. But again, the difference there is for criminal prosecutions, there must be an intent to defraud. The slide makes reference to healthcare fraud and potential exclusion from participating in federal healthcare programs. And that is because many of the false claims lawsuits that are brought under the statute do implicate the healthcare industry, and that's just because fraud follows the money, and there is an enormous amount of healthcare spending in this country, and so many of those lawsuits do implicate healthcare in some way, shape, or form. However, that is not a prerequisite for bringing a lawsuit under the False Claims Act. Any program, whether it's in healthcare or outside healthcare, in which fraud has been committed against the federal government, does trigger False Claims Act liability. So you can have a defense contracting fraud case that would implicate the False Claims Act. You can have fraud against housing programs, for example, that would implicate the False Claims Act. If federal money is involved, the False Claims Act is implicated. Under those qui tam provisions, there is an enormous incentive for individuals to bring fraud to the attention of the government under the False Claims Act, and that's intentional. The design of the statute is to encourage the reporting of fraud against the government. So if a person with knowledge of fraud brings that action, that person is referred to as a relator, and they will collect a portion of the government's recovery if the action results in a settlement or a verdict. It doesn't have to actually result in a formal judgment or verdict. If the government settles the case, that relator will collect a portion of the recovery, and it can be anywhere from 15 to 25% of the recovery if the government takes over the action, often called intervenes in the action, and actually prosecutes the case to conclusion. It's 15 to 25%. If the government declines the case if the government decides no, it is not interested in moving forward and prosecuting the case, but permits the relator to move forward with the case and to litigate the case on the relator's own, then the percentage of recovery goes up to 25 to 30% because the efforts of the relator and the costs incurred obviously go up as well if they are proceeding without the government's assistance. The statute does authorize relators to proceed on their own if the government declines, although the government does have the right to dismiss an action if they do not think it is in the federal interest for it to proceed. 25 to 30%, 15 to 25% of a recovery can obviously mean a lot of money for relators, and many relators have walked away with tens of millions of dollars as a result of their efforts. If the relator planned and initiated the activity underlying the violation, the court may reduce the relator's share of the recovery. And if the relator is convicted of an offense arising from the violation being alleged, the relator would receive nothing at all under the statute. Now let's go to the COVID-19 funding programs and how they implicate the False Claims Act. The CARES Act, which is the acronym for the Coronavirus Aid, Relief, and Economic Security Act, was passed by Congress to address the health emergency presented by COVID-19, and it allocated literally trillions of dollars for pandemic-related purposes. This included financial support for individuals, loan programs for small businesses, economic support for hospitals and other medical providers, and other types of economic support for businesses. Millions of dollars in funding was also set aside for oversight, since such massive public spending created fresh opportunities for fraud against the government by those seeking to exploit the current crisis for personal gain. Remember what I said earlier, that fraud follows the money. Well, that's certainly true in the case of the COVID-19 funding programs, where, as noted, literally trillions of dollars was injected into the economy. And it was injected into the economy on a very compressed time schedule. Literally within months, all that money was injected into the economy and provided through a variety of programs. And when you're putting that much money out there, unscrupulous individuals will take advantage. DOJ, Department of Justice, has signaled that it will use the FCA to enforce the terms of COVID-19 related funding programs to address the health and economic emergencies caused by the current pandemic. So Department of Justice has already laid down a marker and has already stated that it intends to use the False Claims Act to go after those who commit fraud against any of these COVID-19 funding programs. Ethan Davis, Principal Deputy Assistant Attorney General, made remarks before the U.S. Chamber of Commerce in June of this year. And he stated, quote, DOJ will energetically use every enforcement tool available to prevent wrongdoers from exploiting the COVID-19 crisis. In that effort, the False Claims Act is one of the most effective weapons in our arsenal. DOJ will deploy the False Claims Act against those who commit fraud related to the various COVID-19 stimulus programs. In his remarks, Principal Deputy Assistant AG Davis specifically mentioned the Provider Relief Program in addition to the Paycheck Protection Program and the Main Street Credit Facility. These are all programs that were designed to help businesses and the healthcare industry cope with the stresses that came with the pandemic. There are strings, however, attached to all of these programs in terms of eligibility for the money or how the funds are used after you get them, or sometimes both. If you accept money under false pretenses or you use the money in unauthorized ways, that could lead to FCA liability. Why? Well, let's think about it. We just talked about how the False Claims Act creates liability for knowingly seeking reimbursement or seeking payment or obtaining payment from the federal government. So if you lie in order to get money under one of these programs, or you promise to use the money in a certain way and you use it in a different way, then you are creating the factual predicate for False Claims Act liability. Speaking about the Paycheck Protection Program specifically, the Deputy AG stated, vigorous FCA enforcement is more important than ever to ensure that taxpayer dollars are spent as intended, and that the Civil Division's Fraud Section has implemented a number of initiatives to identify, monitor, and investigate potential violations of the FCA in this area, including coordination with DOJ, within DOJ, and with other agencies to identify potential program vulnerabilities and safeguard PPP funds, as well as to identify any potential wrongdoing that warrants investigation. Davis spoke directly about the Provider Relief Fund as well, which is a fund dedicated to helping healthcare organizations coping with the financial stresses of the COVID-19 health crisis. After noting that the Department of Health and Human Services had provided billions of dollars to those, quote, on the front lines of the COVID-19 crisis, he also discussed some of the requirements of the program, including that providers must certify that they have provided or are providing care to those with actual or possible cases of COVID-19 and must agree to restrictions on balance billing patients. He emphasized that where a provider knowingly violates these requirements, the False Claims Act may come into play. He also explained that DOJ's enforcement actions may also include civil prosecution of private equity firms investing in companies receiving CARES Act funding. He stated, quote, when a private equity firm invests in a company in a highly regulated space, like healthcare or the life sciences, the firm should be aware of laws and regulations designed to prevent fraud. And if the firm takes an active role in illegal conduct by the required company, it can expose itself to False Claims Act liability. He warned that where a private equity firm knowingly engages in fraud related to the CARES Act, DOJ will hold it accountable. So, begs the question, how long do these entities have to get into compliance? And have a little cartoon humor here to make that point with Moses and the Ten Commandments. But the answer really is, it kind of depends on which certifications form the basis for liability. As I stated, there can be certifications regarding your eligibility to receive the money, and there can be certifications regarding how you're going to use the money, right? So false certifications regarding eligibility to receive the money are violated the minute you accept money without satisfying those eligibility requirements, and thereby creating a False Claims Act potential liability. False certifications concerning use of the money are violated after the money is accepted based on how the money is spent. Again, creating potential False Claims Act liability. The Deputy AG made the point that minor violations would likely not elicit an enforcement response. He made clear that it's not, the FCA is not an all-purpose anti-fraud statute, which is basically what the Supreme Court had said in a recent case, Universal Health Services versus Escobar. It is not designed for garden variety breaches of contract or regulatory violations. And so he assured his audience that DOJ would not be pursuing businesses for making a minor, immaterial, or inadvertent technical mistakes. He also stated that DOJ would pursue cases only where the borrower knowingly failed to comply with material legal obligations and certifications. If the organization acted in good faith, he assured his audience that they would have nothing to fear from DOJ, which is concerned with only actionable fraud. However, if you're dealing with $3 trillion or more in federal funding injected into the economy, chances are that there's going to be billions and billions and billions taken through fraud. I mean, all you have to do is use the analogy as a sort of a benchmark in the healthcare industry. We have trillions of dollars in national healthcare spending each year, and a very common rule of thumb is that 10% more or less of that amount is lost to fraud. You could probably apply a similar percentage to the COVID-19 funding that was injected into the economy. If even a small percentage, if even 5% of that money were lost through fraud, you would be talking about just billions and billions of dollars. And so the risk is real, and the applicability potentially of the False Claims Act is real, as well as the potential rewards for those who report evidence of COVID-19 fraud. So that was just a brief overview of how the enormous amount, unprecedented amount of COVID-19 funding flooding the economy could implicate the False Claims Act. I fully expect these cases to be brought. I'm sure many have already been filed under the False Claims Act. You can expect many more to be filed over the coming years. Of course, they're filed under seal. You may not learn about them right away. But if, in fact, you have evidence of fraud involving COVID-19 funding, and you wish to learn more about how the FCA might apply, or you have a specific case you want to discuss, you're free to visit my website at www.kaiserfirm.com. You can call toll-free at the number indicated. I'll be happy to answer your questions and evaluate your case. Thanks for watching.